Morning, friends. My today topic is public interest litigation in India. Public interest litigation bill originated in India as a mechanism to provide access to justice for the disadvantaged and marginalized sections of society. The concept of public interest litigation was borrowed from American jurisprudence, but it evolved uniquely in India under the expansive interpretation of Article 32, which is right to constitutional remedies, and Article 226, which is power of high courts to issue writs. These two articles are articles of the Indian Constitution. The origin of PIL in India can be traced to the late 1970 and early 1980, primarily due to the judicial activism of our honorable justices, such as Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. These judges broadened the concept of locus standi, allowing individuals and organizations to file petition on behalf of those who could not approach the courts themselves. If we all know that when we go to Supreme Court and have to file any case, we have to take relevant provisions of the Supreme Court rules 2013. So what is that rule? From where we can file application in the Supreme Court? As far as article is concerned, I have already told this is 32 and 2 to 6 of the Constitution of India. As far as order is concerned, under the Supreme Court rules 2013, that order is 38. And Rule 12 talks about that PIL petition must be filed under Article 32 of the Constitution for the enforcement of fundamental rights as per Supreme Court Rules 2013. And the petition should disclose the public interest involved and the petitioner must act bona fide. This is the overall brief of the Supreme Court rules. The court has, what I say, the court has the discretion to reject frivolous public interest litigations and impose penalties for the abuse of this jurisdiction. There are so many significant case laws on public interest litigation in India. I will go one by one through them in brief. In S.P. Gupta versus Union of India, 1981, what it did, it signified the public interest litigation relief and recognized that public interest litigation is a tool for enforcing the rights of the underprivileged. This judgment relaxed the rule of locus standi, allowing public spirited citizens to file cases for others' benefit. In this case, the relief sought was transparency in judicial appointments and protection of the judiciary's independence. Then comes the case of Bandhua Mukti Morcha versus Union of India, 1984. It focused on the rights of the bonded laborers and emphasized the court's duty to intervene in cases of gross injustice. And the relief sought was identification and release of bonded laborers and ensuring their rehabilitation. Third case under the public interest litigation is People's Union for Democratic Rights versus Union of India, that is of 1982. This case extended the scope of public interest litigation to include the enforcement of socio-economic rights under Part 3 of the Constitution. And it prayed for relief, that was prohibition of exploitative labor practices at the Asian Games construction sites. The another case is Vishakha versus State of Rajasthan, 1997. In this case, the court issued guidelines to prevent sexual harassment at workplaces using PIL as a tool for systematic reform. Relief sought was formulation of binding workplace harassment preventive guidelines until legislation was enacted. So accordingly, the guidelines were issued. And then comes the case of MC Mehta versus Union of India, 1986. This case introduced the concept of environmental public interest litigation. It led to the closure of polluting industries near the Ganga River. In this case, relief sought was implementation of measures to prevent pollution of the Ganga and uphold environmental rights. Then comes Hussain Nara Khatun versus State of Bihar, 1979. This case highlighted the plight of under trial prisoners languishing in jail for long period due to the inability to afford bail. So, speedy trial and release of under trial prisoners whose detention exceeded the maximum sentence for their alleged offenses. This was sought. Then comes the case Olga Tillis versus Bombay Municipal Corporation, 1985. This case recognized the right to livelihood as part of the fundamental right to life under Article 21. And relief sought was protection of slum dwellers from eviction without rehabilitation. There are so many other cases after that, and prior to, I have taken 7 cases. So, reliefs sought in public interest litigation cases, if I summarize it includes policy direction, order to governments to implement or modify policies for public welfare, enforcement of fundamental rights, ensuring that constitutional guarantees are upheld, compensation, awarding compensation to victims of violations or injustice, rehabilitation, ensuring proper rehabilitation of affected individuals or groups, systematic reform, issuing guidelines for administrative or legislative action. So, PIL remains a powerful tool in India for achieving social justice, environmental protection, and government accountability. So, this is all about public interest litigation. In short, this is my 501th video, 501th video, and hope you might be taking interest in watching my videos. Those who have not watched earlier videos, please watch. They are knowledgeable. They are covering our problems of the present era. So be careful, enjoy your life.